Welcome to the presentation on the ethics of subpoenas. This presentation is in fulfilment of Assessment 2 for Ethical and Professional Issues in Psychology, Teaching Period 4. Your presenters are Stefania Merikis, Kemar Janforn, and myself, Danielle Main. I will commence this presentation by first presenting a fictional case study that will provide the basis for the rest of the presentation. I'll then explain in detail what a subpoena is and touch on the ethical issues presented to psychologists when they receive a subpoena and how the Australian Psychological Society's Code of Ethics relates to this case. Stefania will then explore the issues surrounding this case of informed consent and confidentiality. Kemar will discuss non-maleficence, potentially causing harm to the client, confidentiality, and objecting to the subpoena. Recommendations for professional practice will be introduced by Kemar in areas of confidentiality and limits of confidentiality, and Stefania will continue this discussion on recommendations for informed consent, along with suggestions for record keeping, and finally, an ethical decision-making strategy to help cope with the ethical dilemma presented. The case study in this presentation is a 15-year-old boy who was charged with possession of methamphetamines and is awaiting trial. During this time, the boy's parents arranged for a referral for their son to see a psychologist. The parents advised that their son was not going to school and disruptive when he did attend. They feel they could not control him because he comes home whenever he wants and sometimes does not come home at all. During the sessions with the psychologist, the boy discusses his addiction to drugs and feelings of depression. The boy feels misunderstood by his parents and like nobody out there can help him. Drugs are an escape from reality. The boy has disclosed during his sessions that he has been sexually abused by his father, whom he doesn't live with. The boy does not want to report the abuse to police yet. The psychologist and the boy are continuing to address this in their session. The psychologist was subpoenaed to court to produce all client case files. Psychologist notes and reports represent a potentially fruitful source of information for lawyers when their clients are involved in criminal or civil proceedings within a court of law. The psychologist may be a witness of fact and be requested or compelled to offer their notes or their opinion. A subpoena is a court order that compels a person to give evidence or produce documents or both. Failing to do so without lawful excuse is a contempt of court and may result in arrest. The psychologist is mandated to give the information requested, and the need to seek the client's consent to release the information does not apply. The subpoena must be dated with the name and address of the court to attend and have either the court seal or the signature of the court officer in order to be valid. Psychologists can object to some or all of the documents requested being produced by separating them out from any other documents and including a letter to the registrar outlining the reason for objection. Court will then set a date and time to hear the objection and decide if all or part of the documents can be excluded. Grounds for exclusion could include privilege, public interest, immunity, or confidentiality. The psychologist needs to specifically outline the potential harm to the client or breach of confidentiality if the documents are released. The confidentiality or privacy of the psychologist-client relationship will not generally be enough grounds for an objection. There must be compelling circumstances for the exclusion. Given the court is generally an open forum, details from a psychologist's files could be shared with members of the public or even the media if they are sitting in court. The potential harm to the child in this case could be great. And finally, on an important note, psychologists are able to request reimbursement for any reasonable costs associated with preparing the documents for the subpoena and/or attending court. On top of the complexities of surrendering confidential documents or information to the court, the psychologist can face backlash from their clients or be put in a situation which results in them having to answer ethical complaints. The court setting is often highly emotional and concerned parties can be upset by information provided by a psychologist if it portrays them in a bad light. This often leads to complaints against a psychologist, particularly in relation to a breach of confidence. This may certainly be relevant in this case if information about the potential sexual abuse emerges. Psychologists giving evidence are often asked questions that may be outside their level of expertise or competence, or be based on opinion, which violates the APS Code of Ethics general principle of propriety, whereby psychologists practice within the limits of their competence. If in this case, for example, the psychologists were asked if in their opinion sexual abuse leads to drug abuse, then this may be outside their level of competence, as they may not be an expert in the cause of drug abuse and should only make comment on this specific case. And psychologists often attract vexatious complaints, which are aimed at intimidating them from giving evidence about their clients or other parties that may be affected by the evidence. These complaints can be time-consuming and stressful. For example, the father being abusive towards the client may want to deflect attention from themselves by complaining about the psychologist. Whilst the Code of Ethics General Principle B is important, so is General Principle A. The psychologist needs to acknowledge their client's legal and moral rights, recognising the importance of this 15-year-old's privacy and confidentiality, and also his right to participate in decisions affecting his life. Being subpoenaed to court challenges these rights by being compelled to disclose the private conversations held during therapy, if unsuccessful in having the evidence excluded. The disclosing of this information about the potential sexual abuse may in fact do harm to the 15-year-old, which goes against the general principle of propriety. Kemar will further explore this issue of malafeasance later in the presentation. The important issue of potentially disclosing information from the therapy sessions is one that is discussed with the client during the initial consultation under the banner of informed consent. I would now like to introduce Stefania, who will elaborate on the complexities of informed consent.
The requirement that clients should be informed about all the risks and benefits associated to deciding to receive psychological services is called informed consent, and it requires active participation of the client. When working with the young person in this case study, the psychologist responsibly determined that they were capable of providing informed consent by assessing that he understood the nature of psychological services, associated benefits or risks, as well as consequences of receiving or not receiving psychological services. The client further had capacity to make an informed choice, understood the limits to confidentiality, and lastly possessed a Medicare card. The client was deemed a mature minor, and thus informed consent was not required by the client parent. Limits to confidentiality refers to instances where confidential information acquired by the provision of psychological services may be disclosed. A limit of confidentiality relevant to our case study is receipt of a subpoena, where a psychologist is legally obligated to comply and disclose requested client information. Discussing limits of confidentiality with a client recognizes client autonomy in their decision-making. A client can subsequently choose what to share with the psychologist, as well as keeping the psychologist accountable on their promises of confidentiality and privacy.
By the psychologist being subpoenaed to produce all the client's case file, the psychologist was faced with the ethical dilemma of breaching the client's confidentiality, potentially causing harm to the client, and tarnishing the client's opinion of not only the psychologist involved with the case, but of the psychology profession in general. The client file contained confidential information relating of the abuse by the father to the client. The client was still wanting to continue his treatment with the psychologist, and providing the whole client's file could undermine the continuing therapeutic relationship. The psychologist needs to be able to maintain the level of trust that has been developed to continue treatment with the client, as research shows adolescents are less likely to disclose more sensitive information when confidentiality is not absolute. The psychologist might believe the client may cause harm to himself, or the father may threaten or hurt the client if the information about the abuse was disclosed. It could also jeopardise any further legal action relating to the abuse should the client want to report it in the future. The psychologist must comply with the subpoena. However, the psychologist should do so whilst upholding the code of ethics by conducting themselves in such a manner as to minimise any potential harm to the client, as well as reducing the risk for a complaint. The psychologist should ensure that they do not engage in disreputable conduct that reflects negatively on the profession or the discipline of psychology, but unfortunately, breaking confidentiality to comply with a subpoena may be interpreted as doing this. As noted earlier, obtaining client consent to produce the document requested in a subpoena is not a requirement. However, informing the client of the subpoena, asking the client's opinions and feelings about what is being subpoenaed, reminding the client of the limits to confidentiality, legal requirements and the intended actions of psychologists may assist with the client feeling somewhat involved in the process and therefore may assist in minimising harm to the client. In this case, the psychologist should place the whole client's file into a sealed envelope marked objection for production and write a letter of objection to subpoena. The letter should include a request for the records provided, consideration be made to the confidential nature of the documents, which arise in the context of the current professional relationship with the client. Grounds for objection. Sensitive personal health records where the psychologist believes giving access would pose serious threat to the life, health or safety of any individual, both mental and physical, and the undermining of the relationship of trust between the psychologist and the client may cause long-term or irreparable harm to the well-being of the client and the therapeutic relationship, possibly with the treating psychologist and with psychologists in general. It is then the decision of the court what information will be disclosed. This process can assist with upholding standard A.5.4 that only information which is necessary to achieve the purpose of the disclosure is disclosed and only to the people required to have the information. Recommendations for further practice are the psychologist taking the time in the first meeting and when necessary with the client to explain in detail and with scenarios, confidentiality and specifically the limits to confidentiality. This will assist in maintaining the therapeutic relationship. Inform and involve the client where possible of the subpoena and intended actions of the psychologist. Be up to date with current APS recommendations and guidelines relating to subpoenas, and finally be aware of the laws of the jurisdiction of practice.
Establishing and maintaining confidentiality is a cornerstone of the profession. However, confidentiality is not absolute and the limits of confidentiality need to be discussed using plain language during the informed consent process. Good practice for obtaining informed consent is to seek written consent from a client that explains the limits to confidentiality and under what circumstances personal information may be disclosed and to whom. Psychologists have an obligation to attend sufficiently to possible confidentiality dilemmas that could develop if an attempt is made to subpoena the treatment records. Psychologists make provisions for maintaining confidentiality in the collection, recording, assessing, storage, dissemination, and disposal of information. The client should also be informed of these processes. Psychologists should avoid undue invasion of privacy in the collection of information by collecting information that is relevant to the service being provided. For example, the date, time, location, name of client, the nature of services, and actions taken. However, there is typically a lack of formal training in record keeping, and psychologists use their clinical judgment on what is good record keeping. Perhaps this is an area of improvement that could be a focus of training. Psychologists should internalize an ethical decision-making strategy to help cope with ethical dilemmas as they arise. A suggested 8-step model begins with firstly determining whether the matter truly involves ethics. Psychologists are expected to understand the legal context in which they work, and upon receipt of a subpoena, the psychologist should determine precisely what information is required. Step 2 is to consult the code and guidelines, which advise to notify the client and reiterate the limits of confidentiality, such as the legal obligation for the psychologist to comply and disclose requested personal information regardless of their client's consent. It is best practice for the psychologist to initially seek the client's consent to comply with the subpoena. In our case study, the client did not give consent. At this stage, the psychologist requires a signed court order to reveal requested information and also has an obligation to their client to ask the judge to protect the counselling information. Step 3 is to consider all factors influencing the decision the psychologist will make, such as perhaps any financial gain from producing the documents that the courts requested, or the psychologist's desire to protect the client's privacy that may result in them breaching the subpoena and suffering legal ramifications, or how the relationship with the client can be maintained if disclosure is made without client consent. Step 4 is to consult with a colleague for advice and to discuss the best way to proceed. Step 5 is to evaluate the rights, responsibilities, and vulnerabilities of all affected parties, for example, the right of the client to be informed of the receipt of a subpoena. Step 6 is to generate alternative decisions, such as perhaps referring the client to another psychologist if the client's trust in their confidentiality is now broken. Step 7 is to enumerate the consequences of each decision. For example, the psychologist may discuss the pros and cons with the client of giving consent to disclose personal information so that they can make an informed choice. The psychologist can also consider the ways in which they can respond to the subpoena, such as highlighting to the court the risk to the profession should they be required to disclose, and the potential loss of trust of their clientele in seeking psychological services. Step 8 is to make the decision whilst being mindful of how the psychologist can minimise the damage their client could potentially suffer. Minimisation of harm may be achieved by including the client in the process as much as possible.
Psychologists can be faced with ethical dilemmas when issued with a subpoena, such as maintaining confidentiality, balancing a client's needs, well-being, and court order requirements. Psychologists must understand or seek to understand what a subpoena is, how they can respond, and their ethical and legal obligations. Practical recommendations to aid in responding to a subpoena in a professional and ethically considered manner include maintaining good practice by discussing the limits of confidentiality upfront and when necessary with clients, obtain informed consent, and follow an ethical decision-making strategies model.